U.S. versus Hogan, or rather Commonwealth versus Hogan, raises the question of whether there is sufficient evidence to show that the defendant was guilty of unauthorized use of a vehicle and also receiving stolen goods. And in this case, the defendant was stopped at a stoplight for running a stoplight, and he doesn't have any driver's license and he doesn't have any proof of identification of the car. The car in this case had been stolen 4 weeks prior. And the Commonwealth argues that the evidence is sufficient to show that he's guilty of the crime of unauthorized use because, much like for receiving stolen goods, you can show that the defendant is guilty or has guilty knowledge of the stolen goods by virtue of the fact that the goods were recently stolen. That the defendant can explain how he came into possession of the goods, but that it is permissible to draw an inference merely from the possession of recently stolen goods that you are aware that the goods were stolen, subject to like any explanation you want to offer. And so then the court turns and looks at the unauthorized use statute. And for unauthorized use, the court or the Commonwealth doesn't even have to prove that you were aware that you didn't have the authority to use this particular vehicle. It is enough that you were reckless in your belief that you were allowed to use this vehicle when you weren't. And so the court says if the fact that an item is recently stolen is sufficient for us to infer that a person with those stolen goods knows that they're stolen, then if you're driving a car that was recently stolen, it is certainly sufficient for us to conclude, absent some explanation that you might offer either when arrested or through your counsel at trial, absent some explanation, it is reasonable for us to infer that what you have done is that you are aware that you don't have that authority because you're aware it's someone else's car, and that but at a bare minimum, you are at least reckless with regard to the question of whether you had the right to operate that car. So in this case, the court says that even if there's nothing more than the fact that the car was recently stolen, that would be sufficient for a jury to come back with a verdict of guilty under the recklessness prong of unauthorized use of a vehicle, provided that there was no explanation for the defendant's possession of a recently stolen car to be offered at any point, either when he's arrested or at trial. So what does recent mean? Here the court says 4 weeks is a sufficiently narrow window of time since the theft for this to be recent.